kind of tricky. Okay, we're recording this. Can you hear me?
Yes, we can.
Okay, great. Hi and welcome. I'm author and life coach Grace Wroldson. I'm the author of Co-Parenting with a Narcissist, 7 Self-Rules to Stay Sane. It's my survivor story. This has been a webinar put together by me and a special guest for my moms in the Co-Parenting with a Narcissist support group for moms private Facebook group. So if you are a mom co-parenting with a narcissist or in a high conflict family court battle, listen up, because maybe some of this stuff can be helpful or encouraging to you. So my goal is to empower and encourage mothers who are dealing with the dilemma of co-parenting with a narcissist or stuck in high conflict family court battles. I'll give you a little background about me. But I just want to, before I do those introductions, for your safety and to be anonymous, if you're joining this and you're in the live meeting, you can change your name, remove your last name to not be identified, and your questions will go into the chat so that we can see which ones would fit our webinar that we could try to answer. And just a disclaimer, this webinar is just general legal advice and empowerment for you. It's not a substitute for legal advice in your case, and it can't substitute, obviously, mental health services. So I'm not a licensed therapist or a lawyer. I'm speaking from my personal experience and opinions only. Some of this may apply and some of this may not apply for you. So what you like and leave the rest. So I'll just introduce you to me. I am the author of several books on Amazon. My background was loving an alcoholic for 15 years, breaking free of codependency and getting out of that relationship, only to find out that I had to then raise a child with the alcoholic. Halfway through my court battle, I asked my lawyer, why is this not resolving? What's wrong here? And my lawyer informed me that my ex was a narcissist. So I write and speak entirely in a pen name to protect the anonymity of everyone involved, my child, my ex. So, you don't have to label somebody a narcissist. You can call it narcissistic traits or tendencies, or if they're an abuser, you can talk about the abuse. So I protect myself this way in speaking. I've been in family court battles now for 11 years. I've had 3 attorneys. I've had to undergo 3 biased GAL reports, which is a guardian ad litem. I've had 2 parenting coordinators. We've done 3 parenting court-ordered programs. Our situation really didn't resolve in family court. So a lot of interventions were used by family court. I've undergone 2 psychological evaluations, and so has my ex. So I have survived 6 CPS investigations, and we only have 1 child. So I have been in my family court system, which may be different from where you are and how it goes in your case, but you can hear from my survivor story and my survivor wisdom. Take what you like I said, leave the rest. I'm happy to bring you an actual lawyer that I met in a mutual networking group who deals specifically with high conflict cases, family court cases. She's based in the US, as am I. She's on the East Coast here, but every state is different. So before we get into our topics and our discussion and then your questions, I'm going to introduce our special guest, Maribel. So Maribel, would you like to introduce yourself and just talk about your titles, who you are, how long you've been practicing? We'd love to hear from you.
Oh, absolutely. Thank you so much, Grace, for having me. I'm really excited to talk to the moms here and the moms that'll watch the recordings later. So I'm Maribel. Martinez Gunter is my full name, and I'm an attorney. I practice in the state of New York. I've been an attorney for about 25 years now. And in that time, I've almost exclusively focused on working with survivors of domestic violence, of sexual assault, specifically within the realms of family court. I lead a team of attorneys for a nonprofit in New York City. And it's a team of about 5 attorneys and a social worker that are really dedicated towards really pushing the envelope and thinking about not just trauma-informed lawyering, which is the catchphrase that you'll hear, but really thinking about how can we be as therapeutic as possible in a process that is generally not validating, a process that is generally emotionally taxing upon our clients, and a process that's usually not very affirming. So we really lend ourselves towards learning from mental health professionals on understanding the dynamics of trauma on the body and where it resides and how it manifests itself in litigation, and really looking at developing tools and techniques to interrupt those trauma responses so that our clients could have a voice, could speak in their own voice, and could also take ownership of their healing while we're litigating really tough, long, lengthy battles in court. So I'm just really excited to be able to talk to moms and to see how we can get through some of the obstacles that some of the moms may be facing, including like not feeling particularly supported by attorneys, not feeling heard by the legal system, perhaps feeling very judged in the process. Like, how can we work through some of those obstacles so that we could clear the way for a better result in court and ultimately a better family practice long after court's done.
Thank you. So you have tried cases, that is correct, right? In family court?
Yeah. Oh yes, I've tried, endless cases, but my team also of attorneys, we're active litigators. We're in court every single week. And family court practice is a litigation intensive practice. It's not just giving advice, but it's actually representing clients, filing motions, calling witnesses, subpoenaing evidence, and putting on a case.
And your agency actually does free legal services for those who can't afford services. Is that correct?
Yes. So I work for a nonprofit in New York City, and all of our clients are individuals that would qualify as low income, and our services are absolutely free from start to finish. Our clients pay no legal fees at all. And there are organizations like mine in every state. Organizations like mine are funded by Congress, actually, as part of the war against poverty. And there are places that, would be open to hearing maybe some of the cases that we might discuss today. So
Great.
whatever state you are, there's an organization like mine. Mine happens to be the biggest in the country, but there are places like mine all over the country.
Yes, I do know of free legal aid services in my county for low income families and people. So I do know it's available. So thank you for saying that, because so many women and mothers start with, I can't afford a lawyer. Well, what if you can't afford a lawyer? You don't have to afford a lawyer. If you apply for programs, assistance, or you look for these free legal aid agencies and services, you can have a lawyer and you don't have to have such a limiting belief. So as a life coach, I strategize with moms in strategy sessions to just connect them with resources. I also provide emotional support. But what I find is that they have a lot of limiting beliefs, and then that stops them from seeking out help because they think there's no help available. So just know that you've heard today from a lawyer that there are services available for free if you can't afford a lawyer. So let's talk really briefly about family court failures. So sometimes another limiting or a belief that a mom has is that if they believe something, that the courts believe the same thing, and that they think if they're telling the truth, they go in with the truth and it's a straight line to the judge. But they find out it's like a meandering, a wandering maze of getting that evidence to the judge, and then there's a tax coming, and so then it isn't so cut and dry or black and white when it comes to going into family court. You have probably seen family court failures, and you've probably dealt with narcissists or abuse victims and abusers going in having to be forced to co-parent. Is that right?
Mm-hmm. I would say that just about all of the cases that we take, the opposing parties. I mean, I'm not a psychologist. I can't diagnose them, but they certainly do show signs of narcissistic traits. Narcissism is a spectrum, so you can fall anywhere on that range. But absolutely, people, it's not normal for individuals to be in court for years and years. Like, that was never the intention of the family court system. The family court system was intended to be a place where people can go to resolve conflicts that could not otherwise be resolved in any other way. It was never the intention of the court system for children to grow up, in court battles. And some judges have seen that. They've seen cases start where children are very young and the children graduate high school and they're still involved in some level of modifying a court order or enforcing a court order, like just over and over and over again. And when you see that, like, we know that there's something else happening underneath the surface, because that's not normal. For, people go to court, they address their issue. The case could take a long time, but then they go back and they live their lives. They're not, when you see cases where cases are constantly being refiled, seeking additional relief, then we know that that's a clue to some personality traits or other things happening. So yes, it's not a straight line. I often tell our clients, look, I am not going to judge you. People are free to make decisions, and that includes mistakes. And, even if a client decides on a route that I don't personally think is going to give a good outcome, folks have agency. I encourage my clients to take space, within themselves and to utilize their agency. So I do employ reality checks because I think it's really important to counsel and to help my client manage their expectations. But there's a big difference between having an attorney or having a mental health professional that's going to be really supportive, that's going to be validating, that's going to listen with a really open mind. That is a different experience than going to court, where the judge will judge you. That is their job, where the court is interested in the weight of evidence, and the court is making an assessment on your credibility and the credibility of all of the witnesses. That's very different. And so I find that sometimes people can be shocked, because when you go to programs or organizations that are helpers, they're receiving some of that validation, and they think that when they go to court, it's going to be an extension of that. When court is the arena, that is the place where you need to go prepared with a strategy and prepared to withstand everything that comes your way. So you need endurance, and you need a game plan, and you need to be able to detach yourself a bit from the emotional onslaught that happens in the courtroom. And that takes skill, that takes practice, that takes probably a community of supporters that are in your back pocket to be able to do that effectively. That's not an easy task, but that's really what's necessary if you want the outcome to go in your favor.
Yes. So what you're talking about is what I help moms through, is like, we have to get out of emotional thinking. I know you're emotional. This is emotional, but going in strategical, logical, being the more reasonable, cooperative, flexible party who's mature and responding like an adult and not giving too much intel, data, details to the other side, but including them in the child's life and practicing simple business like communication that's friendly. There are so many best practices that I have to share with moms because there's so many things little things they could be doing that get themselves in trouble in the court battle. You want to rage at your ex and you want to talk back to your abuser because now you have a restraining order and now you're not with them. But that standing up and talking back ends up in what I call co-parenting abuse, which is basically post separation abuse or domestic violence or abuse by proxy, where your ex starts using the legal system to hurt you, or doing smear campaigns, or creating negative advocates or flying monkeys, and it becomes, or weaponizing the children. There's so many ways that an abuser can abuse a victim that they're no longer with, and one of them is through family court. And have you seen that happening in your practice?
Absolutely. Abusers have many tools available to maintain power and control. And when that aspect of power and control is threatened because someone's gone to court or they are now feeling like they're in a fishbowl or they're being monitored, they lash out. And so they will call Child Protective Services on you. They will, sometimes contact your employer. They will seek to ruin your reputation. They will try to divide your support group, your family against you. And they'll really seek to turn the tables and present themselves as a victim, which is what narcissists do, right? Narcissists don't take responsibility for their own action. They're not introspective. They don't examine the role that they may have played in something. What they do is they lash out, they cast blame, they devalue you. And part of the trauma bonding is making you feel responsible for the pain that they inflict upon you. And that is a psychological war, lack of a better word, that's really waged. And yes, and they will use the court system as part of their arsenal if they're allowed to.
Yes, and even if you have a court order, they will do things to not follow the court order, to be abusive and uncooperative. And the thing about victims, which you brought up earlier, being a trauma-informed lawyer, when we were in these relationships, these were scary individuals, and we might still be afraid of them. And so, yeah, there's trauma just being around. We don't want to be around them. We don't want to look at them. We want other people around. We want safety. And so it can be very scary bringing a narcissist or our abuser, our ex, into court, trying to get him to do something. And narcissists don't want to be held accountable, and they're entitled. And so when they're told to do something they don't want to do, it can be a lashing out. So I work with moms to build buffers and firewalls and boundaries and psychological boundaries. And like you said earlier, we have this Facebook support group, and I do a monthly free webinar or a Zoom group to bring us together to try to gather that connection and get courage through connection. There's many authors and speakers out there doing this, and I'm just going to be in my little corner of the world trying to shed the light of hope. So this session, I want to get to a couple slides over where we can talk about a couple of key things, because I do consultations with moms, and they're coming up into a hang up with a limiting belief that they can't afford a lawyer, that lawyers will not believe them. That's another one. Or lawyers will be biased or convinced by the other side, or corrupt. And yes, there's corruption anywhere you go, but to have that thought, because when you're dealing with an abuser who has turned family and friends against you, you can become very paranoid and fearful that everyone is thinking what the narcissist has tricked them into thinking. But if we take that everywhere we go, we can't be effective. And so let me just talk about a couple things coming up, and we'll get to that slide. So I am doing a Navigate the Narcissist co-parenting course for 6 weeks. It's 12 videos. We meet once a week. This will be an online learning program, so you can just do the videos and the worksheets yourself. It's basically what I said. Try to get reasonable, rational, logical, and be sane and not be destabilized. So one of the things I say, Maribel, is that a narcissist tries to win by destabilizing the target. When you're falling apart all over, you do reactionary things that can make you look crazy. And of course, they always accuse you of being crazy, but usually they're the one doing the crazy making stuff. So it's important to stay sane and be sure of yourself and get the support you need. And this is my first book that I have in this series, Co-Parenting with a Narcissist. It's about rules that I set with myself. But if you want to be part of that, I do it in small groups. You can apply. I'll have the link below. I'm going to take 5 to 10 moms. We'll journey together for 6 weeks, and we'll go through the videos that touch on different topics. So we're here with Maribel. We have her. The big question is, I always get, is why do I need a lawyer? Can I represent myself? And I always say to that, no, because now that I know as much as I know, it isn't as simple as showing up and filling out a piece of paperwork. There's evidence requirements. There's a process. There's a choreography in the courtroom. There's laws that you need to know. There's things that you can ask for. There's so much legal stuff that you really do. Even the best lawyers make mistakes because it is so complicated, complex. It can be challenging. You got to know your way around. I have seen people make mistakes with paperwork and lose their kids. So that's why I say, yes, we need a lawyer. What do you say to someone who says, do I need a lawyer for a high conflict family court battle with my narcissistic abusive ex? What do you say when someone says, do I need a lawyer?
I mean, that, I understand people having a sense that maybe they are the best person to tell their story. And I agree with that. But when you are in court, my clients are going to have a different experience of even just one appearance in court than I will. I am going to I'm looking at the judge. I'm hearing the inflection, the tone of their voice. I'm looking at body language. I'm looking at what opposing party is presenting. I'm constantly touching base with the attorney for the child because they're usually a linchpin in the case and we need them on our side to be successful most times. I am looking at procedurally what is happening. I am mindful of changes that may be occurring in the law, not necessarily always by statute, because that pretty much stays fixed unless if the legislative body changes that. But there's case law that's constantly coming out and reinterpreting some of the statutes or some of the process. And so I am kind of looking at all of those, legalities and all of the psychological factors that come into the courtroom. And my clients are usually having a different experience. My clients might say, well, that person talked more, or this person, they were yelling, and that is a different way to process what's happening. And it would be it would be really, really difficult for a client to be able to manage both of those things. So, before cases, we obviously meet and prepare and discuss what's going to happen in court so that my clients could feel prepared for whatever stage the case may be. We debrief afterwards. We check in on how are they feeling? What did they see? What did they observe? What do we need to do to prepare for the next one? An attorney needs to process that experience with you, but to do it on your own, I respect people's decision to do that, but that's a huge task to do on your own. I mean, as an attorney for 25 years, if I was in court, I'd probably want an attorney too, unless if I felt that it was just something that was going to be easily resolved on consent, that we were really just seeking an order for some reason. But anything that is high conflict means I am going to be emotionally invested in the process. And it's very difficult to experience something on an emotional level and also be the one mapping out the strategy for the case and paying attention to all the moving pieces happening at the same time. That's almost like splitting yourself into multiple people. Even attorneys that do cases on their own sometimes have a challenge. There's a challenge between being present, being in court, responding to your client who might be passing notes or whispering a question to you, and also taking notes to what is being said and what just happened, because it's not always that you're going to have a transcript for each and every hearing. So that's even a lot to juggle for one attorney to hear and absorb all of that. But now for the person to also experience the emotional aspect and be responsible for all of that, that's a huge task. That's really taxing. And I would imagine that that would be incredibly exhausting for the individual. So I would be concerned that that person would burn out, and because of the exhaustion would ultimately agree to an outcome, a settlement that really is not in their best interest, but because they're just so exhausted and they're so fatigued from the court process, they just want it to end. And that's a dangerous place to be, because that means that you're going to shortchange yourself. That means you're going to agree to something that you will regret, and you'll have an order that might be very difficult to undo later.
Yes, thank you for bringing up all those points. I have seen fathers go in and represent themselves, and they've got tons of evidence. The ex has a past history of abuse, neglect, drug use, and rehabs. And because he's so emotional, he can't even spit out the logical sense that he's trying to make for why the mother shouldn't have unsupervised visits, because she's had them in the past and they failed. And he's so emotional that he can't think strategical and logical and be cool, calm, and collected. So I've seen fathers and mothers try to represent themselves and fail at the last minute. I've also seen where they're trying to submit evidence, but they don't know how, and so it doesn't get it doesn't get approved. So you might have all this evidence in the world, but if you don't know how to bring it in, and you don't have a lawyer who says, oh, this is relevant or that's not relevant, that'll get thrown out, that'll get objected to. If you just don't know, there's just so much you don't know unless you're a practicing family law lawyer. And I've seen people try to use, and this was my mistake, a lawyer who's not a family law expert. So you take a lawyer who knows law and has had clients go into an arena where they don't know the professionals to call on the case. They don't know what the judge typically orders. They don't know how these cases typically go. And it can go to our disadvantage because they are not a family law expert. So when I coach moms and we're talking about getting a lawyer, we're talking about getting the right lawyer and why they need a lawyer. Now, there's also an option of getting consultations and having a lawyer strategize with you, and you don't get them until the trial. Have you seen mothers do that as a way to save on legal fees? Of get a consultation, that'll be the person you have for the trial, but to do all of the middle stuff up until the trial. Is that something you've seen done?
I've seen some aspect of that. Certainly, I think sometimes folks might call even our office and they're just kind of seeing, like, I want to know, this other lawyer said this. I want to know if that's true. How do you see it? Family law is not black or white. Most jurisdictions, most states will have some standard that sounds like what's in the best interest of the child. And what does that mean, right? Like that's this very vague term that is interpreted differently in different jurisdictions. So it's always shades of gray, and it will always shift depending upon the facts as we know them. So if you go to an attorney and you tell them these 10 facts, they're going to give you advice based on what you've shared with them. But those 10 facts are not the only facts of the case. There's a history and a procedure to the case, and there's a lot of extraneous things that are happening. So I do think it's a little challenging, kind of like going in for consultations, but not necessarily having that attorney be the one to carry the ball in the courtroom, because we're going to see things, we may see things differently. Even within my team, I have, like I said, there's 5 attorneys. 1, 2, 3 of us have over 20 years of experience each. And there's times that we will debate cases. We'll debate strategy. And it's in the hearing different perspectives and weighing the evidence differently. Like there might be a piece of evidence, a document, and I might see it and I might give it some level of weight. And another attorney might look at the same document and maybe hear additional facts or maybe hear less facts and assign it different weight. So it really is about looking at the entire constellation of the facts, the evidence, the witnesses, the psychology behind presenting a case. You know, the courtroom is not this magical utopia of, you know, where there is somehow all fairness and all justice and all everything. Like the courtroom is just like society, and society is filled with bias. Society is filled with racism and with, you know, gender exploits and all these other things. And even the best of judges still have biases. And it's important to know who's your judge. How have they ruled before? What have previous rulings in the jurisdiction told? How do we acknowledge some of the potential biases that may be in the case, and how do we work that in our favor? It is possible, right, to leverage a bias in a positive way as opposed to in a negative way. So you have to really understand the psychology involved in a case, and that's really difficult. If you like ask 5 different lawyers, they may have 5 different strategies. So how would you pick who to go with when it's time for trial? And it's not just showing up to court, it's really all of the preparation that needs to be done beforehand, you know, for weeks, maybe even months sometimes beforehand, before you call your first witness, and strategize, what are the questions, what are the points I need that witness to hit. You know, when I was a much younger lawyer, I would write out all of my questions, and you'll see most lawyers do. They write out their questions on direct exam or on cross-examination. And as a young lawyer, I found myself very wedded to this piece of paper that said, but I need to ask this question. And what I found for myself was, I don't need to write down a question. What I need to know is, what point do I need you to hit? What answer do I need you to say? And if I know that I need you to say that the sky is blue, that's the answer I'm going for, then in the court process, I am going to think on my feet, and I am going to figure out, what do I need to ask you to get you to give me that answer, right? And so there has to be a lot of trust that's built in the preparation, so that even if I switch up the order of the questions or ask it in a different way, that we both know where we're trying to go with regards to that line of questions, that my client knows that we have 10 main points that we need to be able to highlight, and that all of the questions that we ask and all of the information that we elicit ultimately are feeding in those 10 points that we're trying to accomplish in the case. So that's a strategy. You're not going to have that same strategy consulting with different people. So maybe that would not have such a great impact on early on in the case when you're still kind of getting your bearings. But once you're approaching a few months before a trial, then that's when all the really serious work needs to happen, in terms of creating a trial plan, looking at a trial book. All attorneys will have a trial book as to how we're going to approach it. So, asking your attorney, can I see your trial book? Can I take a look at the evidence that you think works against me? Like, get involved in that, so that when things are happening in the court, or when you hear phrases or terminology or things like that, you would have some insight as to, oh, that's that thing. I need to be aware of that. I need to pay attention to that.
Thank you. Thank you for that insight. The question at the top about our rights, do you find that mothers or women, it could be men, it's just that my group is for mothers, but victims don't realize they have more rights than they do, that they don't seek spousal support, that they don't seek child support or medical coverage? Do you find that mothers who or women or men use the family courts get more of their rights, and their child get more of their rights met by going through the family court process?
I think it's a range of things. I think people, the times that I do speak to men, most of my clients are women, but occasionally we represent male clients. Occasionally we represent individuals in same-sex relationships, and there is a notion that the women will always prevail in court. And that comes from very antiquated ideas that, that young children should primarily be with their mothers. Decades and decades ago, that was considered like a tender years doctrine. Like, that doesn't exist in the court anymore. What I always observe is that if you have a father that comes to court consistently and says, I want to be involved in my child's life, at least in New York, I'll speak for that, the judges fawn over that. The judges want to roll out red carpets and give that individual even more than they're asking for, because there's such a sense that fathers are not heard, or that they're really not involved, that we have generations and generations of fatherless children. And so when you have a father that really does want to be involved in their child's life, I would say that half of the time they win. So it may, depending on the case, we may start looking at, do we need to pursue settlement over trial? We've had clients who, this trial was the first time that they told their story in public. And, we had one case with a client that she testified so bravely. And that night she went home and she had a heart attack. So there is a weight that goes with this work, with the task of testifying. And sometimes we need to think about the cases where it doesn't matter how much we prepare, it's just not going to, we're not going to be able to execute it and get the outcome that we want. And in those cases, we really push hard to see what kind of settlement could we ultimately have. But the courts really are looking at what's in the child's best interest. That is paramount. And so the courts know that mom's attorney is pushing for mom's interests, whether we agree with it or not. Dad's attorney is pushing for dad's interests, whether that attorney agrees with dad or not. And the only individual that is speaking from the child's perspective purely is supposed to be the attorney for the child. And so what I often see is that if we have a case where the judge is leaning neither towards one side or the other, that the judge will turn to the attorney for the child and say, what do you think should happen in this case? And more often than not, the attorney for the child may be able to sway the judge. So they are a critical piece of the puzzle. And there are things to think about and things to do to be able to win that individual over to your camp, so that when it's time for them to say, what's your position, that their position is going to coincide with our position. So there are deliberate and intentional things that need to be done throughout the course of a case to maximize that opportunity for that to happen. And attorneys are only able to speak to other attorneys on the case, meaning that I would not have direct communication with my adversary's client unless my adversary consented to that, and usually they're not. And so likewise, the child is represented by an attorney. I wouldn't be able to speak to the child about their preferences. The attorney for the child would not be able to speak to my client unless I consented to it or unless I was present. And so oftentimes I will set up meetings that my client and I would have prepared for in advance to go meet the attorney for the child, to go sit down and have a discussion and go over some of our concerns and share some evidence that we think they need to look at. So there are intentional things that are done throughout the process so that our interests could be more closely aligned, and that person could join our side in a sense.
How do, say you're a protective mother, and how do you get an attorney for your child? Is that a request that you can submit to the judge at any age? Is there an age range?
Well, in New York, they're given for any age. Attorneys for children could represent babies, or they could represent children all the way up. Generally, in most jurisdictions, there is some guidance that's offered where the attorneys for very young children are allowed to substitute judgment, meaning that very young children are obviously not going to be able to direct an attorney into the position to take. So oftentimes then it's the evidence, the history of the case, sometimes prior legal records that might influence that attorney as to what position to take. But as the children get older and mature, then the attorney will allow that child to direct them. And so if that child says, I want to spend more time with my dad, then that attorney is going to go to court and say, my client wants to spend more time with dad, and that would be their position. So mothers or individuals that would be our clients, not necessarily that we or the moms get an attorney for the child. The court usually appoints it. If the court hasn't appointed it, then that's something to ask the court, and have a discussion with your attorney as to what is the practice in your jurisdiction.
Yes. So there's rights that a child has, like an attorney for the child, that we don't know about if we're not a lawyer or someone in the family law system. So the other thing is, we don't know how to cross-examine a witness. I mean, we don't know how to object to things. So representing ourselves in a trial can really go against us. And so when people say, why do you need an attorney? There's like hundreds of reasons as to why. Can we talk about a few common legal mistakes that that you see made that mothers can maybe not make? So one of them I know is, not providing discovery and not filling out financial forms and getting them to the attorney. What are some other common mistakes that moms make?
So some mistakes that I see people make is that they will send communication directly to the court. Sometimes people will feel like, I want the judge to understand where I'm coming from. And so they will write lengthy letters or emails and direct it to the court. And that generally the courts will not read those. Generally they will chastise the sender of that document on the record, because if the court were to entertain what's called ex parte communication or one-sided communication, then that would affect whether or not the court was able to reach a fair decision. So that's a common mistake. When people, sometimes you'll see they send pages and pages and pages of documents because they're so desperate for someone to see their side and they don't understand that that is going to have a negative connotation if you do that, and the court's not going to address it. I think another common legal mistake would be not understanding the role of all the individuals in the courtroom, not understanding that the attorney for the child is not your attorney, and therefore anything that you share with that attorney for the child is not confidential. It can be used for you or against you, depending on the position that that attorney takes. I also think a common legal mistake that people make is sometimes not understanding that you may be in a jurisdiction where you can ask for attorney fees, where even if you had to pay for an attorney, and attorneys can be quite expensive, that you may be able to ask the other side to pay all of your legal fees or a portion of your legal fees. So not looking into that, I think, is a mistake. Not having discussions with an attorney or an advisor about motion practice. There's sometimes that some of these cases could be terminated or dismissed if you can craft a motion persuasively enough that rests on some law to say why that needs to happen. So I think that not thinking about filing motions early in the case is a common mistake. Not answering legal papers. So the other side files a petition, that gives an opportunity for you to submit an answer to that. Some people choose not to do that. It doesn't kill a case when you don't do that. It's actually common for people not to. But when you do answer, then the court will always have your version of what you say happened in writing well before a trial is ever had. So I think it's often good practice to answer whatever complaint the other side is filing or petition the other side may file. You give your answer, and it's an opportunity for you to have counterclaims. Often our clients do have counterclaims to make, but they don't often do that. Depending on your jurisdiction, you might also be able to get restitution. Again, that's something to discuss with an attorney. Sometimes you can show that the other side has, there's been some loss that the other side is responsible for, and that you should get compensation for that. That can happen in family court, but not everyone realizes that's really one of the most underutilized statutes in New York are the statutes around restitution. In New York, you can get up to $10,000 in restitution, or you can ask, as a form of relief that the other side pay for your counseling for a period of time if you were seeking certain things like an order of protection, or many things that really could be explored that are there's lots of things in the statute that aren't often looked at. So taking the time even to look at, well, what statute governs my proceeding, and just taking a read. Even if you don't understand all the words or the terminology, I would say look at it and jot down questions and bring those questions to the attorney and see if you can get your own education as to some of the things that the court can do.
So I want to ask this one last question before we move on to any people that want to ask questions in the chat. When you go to therapy and you're in therapy because of the high conflict stress and your ex is abusive, can that therapist be subpoenaed on the stand to testify about the confidential things that you've told that lawyer, that therapist?
Yes, therapists can be subpoenaed. Now there is confidentiality that they could invoke. Depending on your jurisdiction, that confidentiality could be overruled for certain types of cases. Certainly cases involving child abuse or neglect, that information could come in. Depending on the nature of the custody allegations, a judge could overrule that. So yes, you could have a therapist. Sometimes their records won't be able to come in. Those may be protected under HIPAA. Not all of them, but some of them, or maybe a redacted version of records could come in. But yes, they could be subpoenaed. They can be asked to, come to court and demanded to answer questions.
Because a common thing that abusers do is, well, obviously they're abusive. So we usually get therapists to deal with the abusive relationship and the stress of family court. But something they do is they call their victims crazy. And then they build a case around the mother is crazy. And so they say the mother's crazy based on whatever, and look at, there's proof. The mother is in therapy. Let's subpoena the therapist and the records. And so a mom who has been abused going to get therapy now has the person they were using to get help being used against them. Have you seen that in your practice?
So I would say, in those situations, number one, no one is going to know that you're seeing a therapist unless you share that information. Like there's not, or if that information is in some child protective service records from a prior investigation, perhaps. So you can see a therapist and just not tell anybody about it. You could see a therapist and strategize that you do want your therapist to come in and testify. And hopefully over the course of the therapy, you would have had discussions about the narcissist's abusive behavior and the strategies that you had to implement in order to be able to parent during that abuse. So there could be a lot of really helpful things that a therapist would say. But yes, if the narcissist knows that you are receiving services and is able to file a subpoena, and if that therapist, right? So if a therapist is connected to a hospital, hospitals have legal teams, the hospitals can move to quash a subpoena, meaning to eliminate it. It's going to be up to the judge ultimately to decide what goes in and what goes out. But it can sometimes be helpful to have the therapist on board. Seeking help doesn't mean that you're crazy. Seeking help means that you have done what we want people to do, which is seek out systems of support so that you could be the best parent possible. So generally, good judges are not going to hold that against someone because they're engaging in help-seeking behavior. It's when you're not engaging in help-seeking behavior and there's a clear problem that the courts would use that against you, use that as something in a rule against you when you're not looking for the behavior. I've seen that work against someone more than someone seeking help. Someone has an addictive and trouble with an addiction. It's a good thing that they're going to AA or a substance abuse program. That's not necessarily something that's going to be used against them. What would be used against them is if they stopped going. What would be used against them is if they had a diagnosis and a doctor or psychologist saying, this is how we're going to address this diagnosis or this issue. And if the person just decided, well, I'm not going to continue with that, that would be a problem.
Yeah, what I have seen in my coaching practice is the narcissistic ex, it's usually the father, calling the mother crazy, saying that the child has problems because the mother is anxious. So, trying to get the mother psychologically evaluated, or then calling in the therapist to testify, the mother has these diagnoses, and sort of outing and airing the dirty laundry of the mother who was just trying to get through it and get help after she's left her abusive ex and is trying to protect her child from narcissistic abuse from a parent. And that anxiety that anyone would have will be then diagnosed by the therapist, so they're providing treatment and then used against the mother in a family court situation. Have you seen that in your practice?
Well, I'd say it's certainly not uncommon for individuals that have been in narcissistic relationships to have developed coping mechanisms for that. And sometimes anxiety is a byproduct of having lived in that kind of tortured existence with a narcissist, because you're walking on eggshells and you're not sure when the shoe is going to drop. And, you know, you are aware that they're treating you in a certain way, but they always make you feel responsible for how they've treated you. And they may be successful at their job, and their family may think that they're the most lovely person on the planet. And they may have friends that'll say that they'd give the shirt off their back for them. And so there's this incongruency, there's an inconsistency, like a cognitive dissonance, where you're having this experience of this person, but the rest of the world is saying how amazing they are and how lucky you are to have them. It would be really normal to develop some anxiety involved in that. And so if there was a case like that, where someone was using your therapist, or if there was a forensic done and the forensic, you know, collaborated and talked with your therapist or other people, and made an assessment, like, those would be the times when I would say, well, maybe we need an expert in this case. Maybe we need someone that's going to educate the court, because mind you, the judge studied law. The judge, 9 times out of 10, did not study psychology in any great degree. They didn't necessarily, they weren't a social worker before they went to law school, right? Most often, right? They're just lawyers that became judges. So they need to be educated. And so sometimes an effective strategy could be, here's this therapist that's going to say, I've been treating so-and-so for a diagnosis of XYZ. Sometimes you need an expert to be able to piece it together, how maybe that disorder or that behavior is consistent with someone who's been victimized in a relationship. So you can bring in experts that can testify to that. And so you'd want to be able to have discussions like that with an attorney, thinking about what experts do they know? Are the experts local? Are the experts in other states? The good thing that's come out of COVID is that many courts are operating virtually.
Right.
And when you have a court that's operating virtually, that means I can have an expert from Colorado, from California, from any other state testifying in the New York proceeding, and I don't have to fly them in. And it's not a great burden, because they could do it within half an hour, 1 hour, however long their testimony may last. So there are things that we now can do that we weren't able to do so easily before.
Yes, and I'm so glad you brought that up, because yes, we do have more resources that can help us with expert. So what I see is a lot of mother blaming. A narcissist blaming the mother for the child's special needs, for whatever the child has if the child has a problem with the father's abuse, they blame the mother. So I see a lot of mother blaming in our situation. So moms are under attack in family court. It's not the fathers necessarily wanting the child to be with the child, the narcissistic father that we type deal with. It's that they want to win. And the way they've figured out to win is to attack the mom's credibility and to really point the finger at the mom. So the moms are on the defense while trying to protect the children and get the children therapy from the narcissistic abuse. So moms are sort of stretched at both ends. They don't have the money that the father has to keep going or to file motions in family court. So I see a lot of mother blaming, and I think it's hard for us to realize the judge needs to be educated that that is a tactic of an abuser, to then point the finger so much at the other party that no one's seeing that, you know, the father's not even participating in the child's life in normal ways, but very willing to blame the other party for all of their problems. So yeah, I do know some experts that can testify to this dynamic that's been happening with a lot of DV cases. So it's 7 o'clock. I just want to say a few things and then I'll see if there's any questions. This is my Get the Right Lawyer guide. Just like Maribel was saying, it's up to the judge. The judge is going to make a decision. Very few places have a jury. So your judge matters. And I do believe in getting an attorney and doing consultations. If you have an attorney and you're losing, I believe in, like Maribel said, she's got 5 attorneys, they all have a different perspective. Getting another perspective might be helpful if you feel stuck. So if you need that guide, I'll put the link below with a coupon. My new ebook is all of my blogs, basically how I've survived a court battle this long. And it does have my 25 best practices. And my first one is get a competent family law attorney as one of my best practices. If you're on my group, I do have a 7 free tips instant downloadable PDF. You can just start applying these principles to stay sane in your case and don't go crazy if family court starts to, it's a lot of gray to zigzag through. So hold on and hang in there, mom, if you're going through this. All of my books are available on Amazon. And if you want to come over to Clubhouse, I do have a club, Co-Parenting with a Narcissist, that has a lot of replays in there. Maribel's on one of them. She gave some excellent tips, and maybe we will meet up in there and have a regular club where you can come and ask questions. I want to stop this recording and thank everyone for coming to this webinar. Hope you learned something. Type down below if this is on YouTube what the takeaway is, and look for some more of these sessions either on Clubhouse or in the group. So thanks so much. Everyone stay here while I stop